This is an appeal in the matter of the King and the application of Fatima Omar Ahmed al-Hashimi and Secretary of State for the Home Department.
Yes. The lady. I appear in this matter with Moylan Jr. Mr. Cooper, representing the Secretary of State is our learned friends Mr. Blundell, King's Counsel, and Mr. Laird. I think there's one piece of housekeeping that having been in court for the last 10 minutes, I think has been addressed, which was there was a slight problem with the authority fund. One of the Secretary of State's cases, the wrong citation was provided. That has been swapped over.
Right.
In the bond
Thank
fund.
you.
Other than that, as far as I'm aware, the court should have 3 bundles of authorities and a core bundle and supplementary bundle.
Yes. Yes.
I don't think there's any other housekeeping, so in light of that, I may as well move subject to anything the court wants to raise straight to the submission. What I propose to do is deal with the facts first, then deal with the issues of jurisdiction, and then finally deal with Article 14 for substance.
Yes, I mean, one thing we might need to consider is whether, if you were successful on your ground 1, whether we would then determine the issue, or whether it would be more appropriate for it to be sent back, remitted.
Yes. Obviously, I think the parties have expressed in a position in relation to that.
Yes.
One sense, there's probably little more I can say about whether it should stay in this court or be remitted. The one thing that might assist the court is that obviously one of the features, or one of the matters that we argue is that the specific nature of the Article 14 argument is relevant to jurisdiction. Things might be different, for example, if this was like a pure Article 8 argument. So there will be a certain amount of Article 14 case law that does need to be opened in the context of the jurisdiction issue.
Yes, I mean, I think our current view is that if you were successful on ground 1, we would not ourselves determine the discrimination issue, and we would remit that.
Well,
so, I mean, when you come to it, if you want to say anything else to try and persuade us otherwise, please do.
Yeah.
But if you don't persuade us otherwise, then you'll be able to deal with, I understand you're saying it's relevant, but you'll be able to deal with a much lighter touch than otherwise.
And it's certainly not necessary. That's a helpful indication. It's not, I accept it's not necessary for me to go through the entire Article 14 argument for the point I want to make about jurisdiction.
Yes.
It's a relatively limited part, I accept, of the Article 14 argument.
Right. Thank you. Yes.
We'll turn then to, fairly briefly in one sense, the facts, because the facts are pretty clear and undisputed, obviously, and recorded both in the skeleton argument and the judgment below. There are 2 aspects, though, of the facts that I wish to emphasise. The first is that it's clear that the applicant lacks British overseas citizenship because, at the material time, citizenship was passed on down the male line. And I've spoken with a friend about that. There's no dispute between the parties that that is an accurate description of the historic position, and my lords, my lady may well have picked up the reference we've made in our skeleton arguments to the judgment of Lord Sumption in Roman and Advocate General, which is in the Authorities,
Yes.
Volume 1, Tab 2, Tab 22, page 547. May not need to go to it. It's para 4, where he talks about how that is a curious survivor of redundant social and political priorities.
Yes.
But that, as I say, is not in dispute. The second point, which I just want to highlight because it's relevant to the issues of jurisdiction, is that the appellant's evidence gives, it sets out why it matters to her that she's a British overseas citizen. And the one point in that I'd wish to highlight is that one of the matters she raises, and we say this is important potentially when you come to jurisdiction, is that one of the benefits of overseas citizenship is it allows an individual to seek consulate assistance. And that's important because when one comes to jurisdiction, the European Court of Human Rights has made clear that consular assistance is something that clearly does come within the jurisdiction of the state, even if that assistance is provided in a third country. And so what is in issue is a precondition to that matter that's clearly within jurisdiction. I then turn to what is likely to be the bulk of my submissions, which is jurisdiction. Starting point is that, despite the efforts of both parties, no one has been able to identify any case law that is directly on point. That is, we submit, not fatal, but we accept the correct approach is set out now by the Supreme Court in Birmingham City Council and Jones, at page 979 of the authority, paragraph 38.
Can you give the tab number?
Sorry, yes, yes. Yes, I had them to tab 33.
Thank you. Sorry, did you give us the paragraph number?
Yes, 38, but the relevant page bit is, that stretches over 2 pages, and the relevant bit is on page 979. And this is what we submit is the key sort of principle that needs to be applied, or the key approach that needs to be applied. Just below the letter A, you'll see it's not the function of the court, we accept this, to undertake a substantial development of convention rights. But what is recognised is that rights should be able to be enforced domestically under the Human Rights Act, and so there should be a correspondence between rights under the Human Rights Act generally and the Strasbourg Court. And then linked to that, as a result, by letter C, it is open to the court to apply principles established in the Strasbourg Court's case law to novel situations.
And is that what you say we are?
That's what we say we're inviting the court to do. What we're seeking to do, what I will seek to do when I go through the Strasbourg case law, is look at the principles that it's identified and seek to apply them to this situation, which I accept is novel.
Mr. Sutley, the Birmingham City Council and Jones is a case where there was no doubt that the court had jurisdiction. You can't apply case law to novel situations to create a jurisdiction where there isn't one.
Well,
I'm not sure that this particular passage helps you one way or the other, because what Lord Lloyd Jones is talking about is the application within a domestic context of rules that apply within the domestic context in a situation to which they've not been applied before.
But the point I'm making, which is why I would submit it as sits, is that case law recognises, and I was going to come on to this, that when looking at jurisdiction, one applies the approach of the Strasbourg Court. Now, the Strasbourg Court, the position we submit is the Strasbourg Court has identified principles. It hasn't been asked to apply those principles in the circumstances of this case. And so, because of the basic principle, which is the domestic courts should sort of march hand in hand, I think is the language sometimes used, with the Strasbourg Court, then it it's appropriate to apply the principles in a novel situation.
Well, I completely understand that you can say, well, I can draw certain principles from Strasbourg authorities to apply to this situation, which, if you accept those arguments, means that there's jurisdiction. But I'm not sure that this passage really helps one way or the other in relation to that. I mean, the starting point, surely, is that jurisdiction is territorial. That's established by a very, very long line of Strasbourg case law. And so you have to say, where is the territorial nexus here?
Well, my lady, I'll come on to the case law. I don't accept it's necessarily quite as straightforward as that, in that the court has recognised territorial is a starting point, but the key issue is jurisdiction. I'll come on to that, my lady, because
Okay, have we finished with Birmingham?
yes, we have. The other thing, just in terms of principles, which in some senses reflects that, is Smith, Judgment of the House of Lords, to remember rightly, Volume 1, tab 16, page 247.
Yes.
30 deals with and comes back to a concept that will become clear, hopefully. It starts by dealing with a concept that will become clear when I take you to the European Court of Human Rights case law, and it deals with which is that there can be exceptional circumstances where jurisdiction is exercised outside territorial boundaries. The Supreme Court, rather, it wasn't the House of Lords, makes clear 2 points. One links back to the point I was just making, which is by just below letter B, 6 lines in, rather, it's the sentence that starts secondly. That is a statement that the list of circumstances, essentially, of where jurisdiction has been found is not closed.
Sorry, where are you?
By just below letter B on page 247 in paragraph 30, it's 6 lines in, secondly, the words to date.
Yes.
So recognising, again, consistent with what I was just saying about needing to identify principles and apply them to novel circumstances, that the fact there isn't a case on point is not necessarily fatal. Also, just so I don't need to go back to this, linking to a point that I'm going to come to in the case law, just before that, the 2 sentences that start first in line 1 of paragraph 30, they recognise that exceptional, which is the language one sees in the European Court judgments, exceptional in this context is effectively the language used to describe the circumstances in which you can depart from territoriality. Exceptional, we submit, is meant to demonstrate that there is a presumption that territoriality is determinative, but it's only a presumption. It's another way of putting it is that exceptional is an expectation that it will be rare, but ultimately the question is, has the presumption been displaced?
So what this is in the context of the quote, which is that the jurisdictional competence is primarily territorial.
Yes.
But then the court in its case law has recognised a number of exceptional circumstances capable of giving rise to, etc. And your case is going to be that although the court has not yet recognised the circumstances or circumstances similar to this case as being exceptional circumstances capable of giving rise, they are exceptional circumstances. Is that how it goes?
Reason, yes. And can I just explain the reason for that? briefly, just to summarise, so you understand where I'm going. A couple of things I should say actually in response to that. Firstly, just to note, the quote was that precedes this was taken from Al-Skeini.
Yes.
I'm going to take you to Al-Skeini next because I accept that in one sense is the key starting point. Secondly, more specifically answering the question, what we submit is that ultimately the focus needs to be on jurisdiction because that's what Article 1 expressly requires consideration of. The exceptions are ones where, as a matter of international law, jurisdiction is enjoyed by the state whose conduct is in issue. And in this context, the United Kingdom does have relevant jurisdiction.
Well, just so that I'm clear, is it your case that in this situation the state is exercising jurisdiction extraterritorially?
It is our case that, well, it's
That's what the exception applies to.
Yes.
So you've got a situation which is primary case is you've only got duties under Article 1 within the territory, or
Yes.
if you're exercising a jurisdiction in the territory. There are exceptions to that where the state is recognised as exercising an extraterritorial jurisdiction. Classic one being where you've got a delegation or some kind of consular relationship in a foreign state.
Yes.
But what I'm keen to know is, are you saying that on the facts of this case, you can point to something which shows that the state, i.e. the UK, is exercising its jurisdiction extraterritorially in relation to this matter?
Well, the way in which I would put it is that it is extraterritorial to this extent, which is that obviously physically the appellant is outside of the United Kingdom.
Yes.
So the effect it has on her and her rights is at least in part outside of the United Kingdom. However, the question then arises is what, as a matter of international law, it is the United Kingdom's jurisdiction in relation to it, and we submit that the relevant impact, which is on the bond between her and the United Kingdom, it is one that remains within the United Kingdom's jurisdiction because it's for the United Kingdom exclusively to determine who is a national. Now, I'm going to turn, having identified those two authorities that may be of assistance in terms of the general approach, I recognise that decisions on that R3, and I'll come to R3, I won't take you to it now, makes clear, and we don't dispute, never disputed this, that even though Article 1 of the Convention is not expressly incorporated into the Human Rights Act, it is for this court to effectively apply decisions of the European Court of Human Rights in relation to Article 1 when determining jurisdiction. So certainly we would submit the important starting point is those decisions of the European Court, and certainly we would submit that generally the approach of the domestic courts has been to in particular start with Al-Skeini. And Al-Skeini, the relevant passage, starts, it's in volume 2, tab 42. And it starts at page 127. The relevant passage starts at 1275.
Yes.
And 1275 is where the court sets out its general principles, starting with, unsurprisingly, a citation of Article 1, and that's just worth looking at briefly because it makes it clear that the language used, and that goes back to what we said about exceptional, which is exceptional must be an expectation rather than anything else. The language used in Article 1 is that of jurisdiction. And ultimately that is what we submit needs to be focused on. And we'll come to authority, more recent authority, which makes it clear that jurisdiction should generally at least be applied taking account of international law, public international law. Going over the page, the European Court makes clear in the same paragraph that jurisdiction is a threshold criteria, and the exercise of jurisdiction is a necessary condition for a state to be held responsible. Can I emphasise the words exercise of jurisdiction? That suggests that in one sense what one needs to focus on is what the state is doing, it's relevant obviously to the alleged breach, because the question is what the state is doing within jurisdiction. The court then goes on in para 131 to make clear that jurisdiction is primarily territorial. This is essentially what was being addressed by the Supreme Court in Smith, but that acts, this is why I was talking about the location of the appellant in this case, acts producing effects outside of the territory can constitute an exercise of jurisdiction in exceptional cases. That exceptional cases language is repeated, as far as I'm aware, in pretty much every, if not every, Strasbourg authority that's relevant. What the European Court then goes on to say, which is of some importance in para 132, is that, and you see this right at the end of para 132, that when determining whether exceptional circumstances apply, there is a need to refer to the particular facts. That's important. It supports an argument that we make in relation to our reliance on Article 14, that it is important to consider which right is an issue. That's consistent with a more recent judgment of the European Court of Human Rights, HF in France, where the European Court did reach different conclusions about different rights, despite the fact that the individual was outside of France's jurisdiction. And it is also consistent, I suppose, with what I've already said about the need to identify principles and then apply them in the circumstances of this case. Court then recognised 133 that jurisdiction, territoriality, there may be an exception where acts of the authorities produce effects outside their own territories. And the first exception it gives is consular.
Well, before it says that, it says it's necessary to examine the court's case law to identify the defining principles.
Yes.
So the following paragraphs are seeking to identify defining principles.
Yes.
Right.
That's right, my lord. The one sort of caveat I would say in response to that is that although that is clearly what the court says, is when you look at particularly para 134, and we submit a para 134 is of importance, and I'll come on to why we say that's of importance. To some extent, what the court is actually doing there is identifying an example of an exception to the general rule, without necessarily saying a huge amount about why that exception applies. There is a little said about it, but not. It's more, we would say, focused on the fact of an exception.
It's an established exception. What they're saying is, here are circumstances in which the court has already recognised that there is jurisdiction of an extraterritorial nature, and it refers to Bankovic and all that line of cases, which of course was why I gave the example that I did when I put the question to you. So there are a number of situations which have been recognised as engaging jurisdiction, and these are they.
Absolutely, my lady, and yes, absolutely. That's sort of what perhaps inelegantly I was sort of trying to say. It was that they're examples given rather than, in one sense, statements of principle. Albeit, if you go to them, para 134, and it's one that we place particular weight on, that example, when it looks at the issues of the issue of diplomatic and consular agents, it identifies Bankovic, Milady's right, as being the basis for its conclusions regarding that. I'm going to come to Bankovic. But it also makes clear that the reason, or implies at least, that the reason why diplomatic and consular agents are within scope is because international law provides for that. And that's important because the case law that I'm going to come to perhaps places greater emphasis on the importance of international law, makes it clear international law is highly relevant in interpreting Article 1. And what international law seeks to do, and again we submit this is consistent with case law, it's not so much identified in Alsgaini, but it is certainly identified in Bankovic, and it's identified in more recent cases. What international law seeks to do is identify specific situations where a state effectively is obliged to recognise decisions of other states, even if they have effects within its own territory. And decisions on nationality, we submit, is an example of that, as are decisions on consular agents.
So can I just understand?
Yes, sorry.
No, well, going back to 134, you point out there's a reference to in accordance with provisions of international law.
Yes.
So what do you understand the significance of that to be in this example?
Well, yes. What I understand the significance of that to be, and I'll come on to the provisions of the Vienna Convention in relation to it, is that what it is saying is that, to use an example, if a consular agent, if someone is arrested, if a UK national is arrested in France, the UK has a right under international law to send a consular agent to see the French national.
Sorry, the UK national.
The UK national. Sorry, the UK national. Yes, yes. Sorry, that was yeah. So the UK has a right, even though the UK national is in France, they have that right, and that is, to some extent, it's an international law provision that restricts French sovereign rights and gives the UK additional rights outside of its territory. But that brings the matter within jurisdiction for the purposes of Article 1, because international law recognises that.
So just, can I understand?
Yeah.
This isn't particularly concerned with the right to consular access, is it?
No, but it's an we just use that as an example of it. It is concerned more generally with the rights to have consular agents, etc.
I follow that.
Yeah.
So just to understand, the starting point is people within your jurisdiction. On the face of it, that normally means your territory.
Yes.
But here you have people who, in accordance with international law, are representatives of the state in another country.
Yes.
Doing something.
Yes.
So the court says, well, we're not going to restrict you to your own territory. If in accordance with international law, you're somewhere else and you do something, that counts.
Yes, because the UK, in the example I'm giving, the UK is fundamentally exercising a jurisdiction it has as a matter of international law, even though the physical location of that exercise of jurisdiction is France.
Well, the classic example is an entry clearance officer in a foreign country exercising the Secretary of State for the Home Department's powers in relation to immigration control as to who can come here as a visitor and so on and so forth.
Well, my lady, I would submit, I mean, yes, I don't disagree with that as being a classic example, but the question, the 2 points I'd make in relation to that. One, the question arises, why is that, as I say, within the UK's jurisdiction? And what we submit, particularly that reference to international law in para 134 and Bankovich both indicate, the reason why that consular officer is within the UK's jurisdiction is because international law permits them to perform functions overseas.
Well, it's because the UK, in accordance with its legal, what is permissible legally, is able to exercise it and therefore does so. So what actually engages the extraterritorial principle is not anything to do with where the rights come from. It's the fact that they are legally doing what they're doing overseas. It doesn't matter whether it's international law or domestic law. What really matters is that they're exercising a jurisdiction overseas, in fact, lawfully.
Well, except the reason why I emphasise international law was suppose, and this becomes clear in other case law. Suppose domestic law said we can send police officers into France to arrest people. That would be prima facie contrary to that would raise all sorts of issues as a matter of international law, because it would be restricting, in one sense, the jurisdiction of France to decide what happens to people physically within its territory. That's why the focus in our submission has been on international law, because international law can ensure that, if you like, both the United Kingdom and France are recognise, if you like, the United Kingdom exercise of jurisdiction. And lady, that's why I focused on international rather than domestic law. I mean, the other problem
What matters is that it's lawful.
But
surely.
Well, the question is lawful under what law?
Why does it matter? It's got to be lawful. Obviously, it's got to be lawful in the territory where you're exercising it. I don't know why we're labouring all this point about international law all the time. I mean, surely the heart of your case has to be that in some shape or the other, in relation to your client, the UK is exercising extraterritorial jurisdiction.
Well, absolutely, my lady. But and that is our case.
What I'm really interested in is how you say it's doing it.
Well, my lady, we say we're doing it as a matter of domestic law, because obviously domestic law provides for the grant of British overseas citizenship, but also as a matter of international law, because as a matter of international law, it is for the United Kingdom to decide who is its citizen.
Yes, okay.
Can I just, before moving off Hashimi, because the other sort of examples given, I accept, are more off point, and we do submit the consular access point is on point in one sense, not least because I've already made the point. It is a precondition to consular assistance that someone is a citizen. The other passage I just wanted to draw attention to, because it is again recognising the potential relevance, at the very least, of international law, is when you go to para 135, which is about where a state is invited essentially into another state. The European Court at the bottom of the page, second last line up, emphasises how that is in accordance with custom, treaty or other agreement, basically. So again, suggesting this need for, if you like, mutual recognition, perhaps it is one way of putting it to avoid going back into language of international law, mutual recognition of the other states' actions. Can I just, before turning away from Hashimi, just deal with one issue that we've raised in our note in response to a submission of the Secretary of State in their skeleton argument about para 19. The Secretary of State argues that the test in this context is special justification. That is not language that is found in the reasoning of Hashimi as to, or in the statement of principles that are applied in Hashimi. It's language that is found in analysis of a judgment of Lord Brown in the House of Lords, and it's a language that's found in relation to government arguments. We submit that test is potentially unhelpful unless it's understood that it is special justification, essentially is, again, understood as being an expectation that cases will rarely be ones within jurisdiction if someone is physically outside the territory. What we submit is that Hashimi effectively is a more recent Grand Chamber decision, and it sets out the correct principles, and they're the ones I've just taken you to. Bank of it.
The words that appear quite frequently in these paragraphs are authority of control. And in paragraph 137, the summary is clear that whenever the state, through its agents, exercises control and authority over an individual, and thus jurisdiction. So it's control and authority in the territory of another state. Is that a fair summary of what that if you're looking for a defining principle?
Yes, subject to one caveat or one nuance that needs to be applied to it, and that comes from HF, which I'm going to come to.
Okay.
The nuance I would add to it is that it doesn't necessarily need to be control or authority in relation to all issues. It can be in relation to a specific issue. So that in HF was the case that was concerned with, and I'll come back to it, French nationals who were in a Syrian...
Come to HF when you come to it.
Yes. Can I then go back to Bankovic, because it is footnoted, it is the basis of the consular access case, and it does add a little in my submission that's relevant. Bankovic is at volume 2, tab 38, page 1, the relevant page starts at 1139.
Can you just remind me what was the sort of consular relevance in that case?
I'm just trying to remember why consular access became an issue. I think it was just being identified essentially as being a ground. When the court was identifying principles.
Okay.
It was identifying that and explaining why it applied and why you could distinguish the approach that was going to be adopted in Bankovic.
Right. Okay. So where are you taking us?
Para 1139.
Page.
Sorry, page 1139, para 57.
Yeah.
Where the court sets out some principles, and it notes worth noting it starts from indicating that it's considering international law, because it looks at international law, consider circumstances, international laws. When it looks at the circumstances, rather, when a state can exercise jurisdiction extraterritorially consistent with international law, and in that context, it notes diplomatic and consular relations.
Sorry, I'm not keeping up with you.
Sorry, it's I was expressing myself badly.
Yeah,
if you look at paragraph 57, second sentence, and it notes that international law does recognise in certain circumstances, or might recognise in certain circumstances, extraterritorial jurisdiction, one of the examples being diplomatic and consular relations. Another actually being nationality, or directly on point. It then goes on at paragraph 58, and this links back to a point I was making to my Lady Justice Andrews about the state's competence to exercise jurisdiction over its own nationals abroad is subordinate to that state's and other states' territorial competence. So what it is recognising there, and this is something that comes up in more recent case law, perhaps case law more expressly, is you can't have a situation effectively where one state is being expected to exercise jurisdiction if the consequence of that is it impinges and restricts another state's jurisdiction. So to go back to the consular, it's why I gave the consular access example. Because international law recognises consular access, if one state exercises its rights in relation to that, that's not restricting another state's rights, because that state has recognised as an international law that. Nationality is in that list because, as the case law makes clear, if state A says that you're a national of state A, state B has to recognise that. There's no role in state B saying, well, actually, your nationals are only X, Y, and Z, because that undermines state A's ability to decide who is a national. That then is the context of paragraph 71, and 71 is where the statement about diplomatic agents is recognised, and it's based very clearly on international law.
It's one of these funny situations where you get in Al-Scaini a reference back to this case as a source of the principle, but actually this case doesn't really take you anywhere. No. It's not dealing with these facts either.
No.
And it's not even identifying the prior case, but still.
No.
It's a case which actually decides that bombing Yugoslavia is not something which engages the jurisdiction of the UK.
Yes, that's
what it decided.
Absolutely, but
and in fact, the real ratio is at 73. Court considers that the applicant's submission is tantamount to arguing that anyone adversely affected by an act imputable to a contracting state, wherever in the world that act may have been committed or its consequences felt, is thereby brought within the jurisdiction of that state for the purposes of Article 1 of the Convention.
Yes, and I accept one of the features of this case law, and I'll come on to that, is that this line of case law is that there is a concern of the European Court that it's not going to impose obligations on member states of the Council of Europe to sort out human rights abuses everywhere in the world, no matter what the ties are and the specific ties are. But the 2 points, the reason I've taken you to it, just to be clear, are firstly, and this is probably the most important one because it's the origin of something that comes up later, and it's why we focus on nationality and the status of nationality in international law, that there is a real concern that if you extend jurisdiction too widely, this is from paragraph 58, you have the effect of limiting the jurisdiction of other states. State A has a wide jurisdiction in State B, that restricts State B's jurisdiction. And that is stated there. It doesn't really feature in Alsgaini, but does feature in later judgments. And that's important because if State A decides you're a national, that doesn't restrict State B's jurisdiction.
I see you do get the word special justification in paragraph 59.
You do, but that's why I said this obviously precedes Alsgaini, and to the extent special justification means something more than simply an expectation that it's going to be rare that you have extraterritoriality, we submit it isn't then adopted in Alsgaini, although obviously other bits of it are. The second thing I get from it, which is why I take you to it, is that the Para 71 is much clearer about the origin of the position of diplomatic and consular agents being international law. And that links into more recent cases which emphasise the importance of international law in this context. The third case that I wanted to take you to, because it makes clear one thing which is important potentially to our arguments, and that is that the approach to rights, the approach to jurisdiction may depend on the rights at issue, is HF v France. And that is in volume 3, tab 55, 2103. Sorry. And this was a case about some French nationals who were whose children were had travelled to Syria to join Daesh, and who were then stuck in Syrian refugee camps, Syrian prison camps rather, and stuck with their children in Syrian prison camps. And what the applicants sought were repatriation of their children. And why this is particularly important is the European Court reaches different conclusions. The two rights relied upon were Article 3 of the Convention, because of the conditions that were found in the prison camp, and Article 3.2 of Protocol 4, not something that is an issue in this case, or could be an issue in this case because it's not a provision that the UK has yet ratified, but it is about the right to enter France, the right of nationals to enter France. And the key point is that the European Court reached different conclusions about jurisdiction in relation to the two issues. So it found that the issues were outside of the jurisdiction of France. The issues in relation to Article 3 were outside the jurisdiction of France, but the issues in relation to the right of entry were inside. Before going to the court's reasoning in relation to that, can I just draw attention to, because it goes to something I'm going to come to, which is the nature of nationality. It's worth noting that the European Court considered the nature of nationality at page 2131, paragraph 84, 5 and 6. '84 cited a judgment of the International Court of Justice, noting that's a judgment I'm going to come back to when I look at the issues of nationality. But the key point about that is what is said just, and you see it referred to in a Northern Irish Court of Appeal judgment as well, is the second sentence, I think it is, that is within the citation of note form in 84, which makes it clear that what is key about nationality is it's an expression essentially of a legal, well, it's actually the whole of the paragraph. What's key about nationality is it's an expression of a legal bond between a particular individual and a state. What the European Court went on to indicate was that it thought it was relevant that there were two key legal consequences as a matter of international law in terms of nationality. You see those at para 86. The first of those that's identified is the right to diplomatic protection. And that's important because it demonstrates an issue that we have relied upon, which is the relationship essentially between nationality and consular access, something we would submit clearly comes within jurisdiction. Essentially, nationality is a precondition to consular access.
That's the point.
Yes.
Nationality is a precondition. So once somebody is a national, they have certain obligations and certain rights. They have rights to enter, reside in, leave the territory of the national state. They have the right to consular access when they're abroad. They have various rights. Once they are a national, doesn't tell you anything about the whether or not the state is exercising extraterritorial jurisdiction when it's deciding whether or not to make someone a national.
Well, I'm not sure I would necessarily fully accept that, in the sense that if, for example, the right to consular access and the human rights in relation to that are to be effective, then, and we would certainly argue they can't be denied on a discriminatory basis, then the precondition to those, if the rights are to be effective, also potentially comes within jurisdiction. Because otherwise, what a state could do, instead of, if it wanted, for example, to deny consular access on a discriminatory basis, it could deny nationality on a discriminatory basis as a way of doing that. And it would be odd if nationality, if the consular access were in jurisdiction, but the precondition were outside jurisdiction.
Sorry, the starting point is that a state has absolutely unfettered decision as to who it makes its nationals and what the tie is and how it deals with it. So, with respect, the idea that a state is going to act in a discriminatory way in order to avoid having to give somebody consular access doesn't really make a great deal of sense. What you have to argue is that by some kind of extension, the principles that apply when somebody is already a national should apply to selecting whether they should be a national.
Well, lady, I accept the example I was giving about discriminatory denial is probably an extreme example. It may not be, but it's a way of testing out the relationship in my submission. But I accept if I'm wrong about that, then it is, what we're trying to do is draw out by analogy. And the analogy we rely on, and this is probably in one sense the more important point, is why is consular access a matter that is within jurisdiction? It is within jurisdiction, we submit, because international law provides for that. Well, international law also provides for states to determine who are their own nationals. Can I just also pick up one point, because I'm going to come back to the Article 14. The state's jurisdiction, essentially, in relation to nationality is fettered potentially by Article 14, because while states have very broad discretion as to who is a national, it's pretty clear one can't do that on a discriminatory basis.
Why not?
Because
Article 14 doesn't exist in a vacuum. Article 14 has to be read in conjunction with another right. You only get into the territory where there's another right, where you've got jurisdiction to determine that somebody's rights fall within your territory. So it becomes a circular argument. You can't say, oh, it's discriminatory generally on a prohibited ground, and therefore I can rely on Article 14. Because that's not the way that the European Court or the European Court of Human Rights have ever looked at Article 14.
Well, lady, I accept I have to establish jurisdiction, and I can't just say there's been a violation of rights, so that gives rise to jurisdiction. But equally, both the European Court and the Supreme Court have accepted that in principle, Article 14, and on particular facts, Article 14 is violated by discriminatory denials of citizenship.
Provided that there is an engagement of another human right.
Well, Milady,
There's got to be it's either got to fall within Article 8 or Article 1 Protocol 1 or both.
well, Milady, the test is actually, we submit ambit, and that has a material impact here. Ambit is not necessarily the same as whether or not there's an interference with Article 8. And that has a material impact in relation to citizenship.
But there still has to be jurisdiction to determine an Article 8 claim. That's the point. Ambit is indeed the right word.
Well, Milady, I don't necessarily accept that for the reasons I'm going to come on
But
to.
you can't, because there is no engagement with Article 8 in this case. So you've got to say that all of this line of case law is wrongly decided, or that there is a need to extend it in order to cover a situation where Article 8 isn't engaged and the person concerned is well outside the territory because it's discriminatory.
Well, see, I don't accept that I'm having to say all the case law is wrong. What I'm submitting is that the key issue is and this is why I was taking you to HF, because it focuses on what the factual issues are that are raised by a particular claim.
I'm not sure that I've yet discerned which other passages in HF.
Yes, certainly.
We were at 84 and 85.
Yes, I was just setting out what the background was, and
Okay.
got these slightly. But if you then go to, I took you also to para 84, which talks
Yes.
about nationality.
Yes.
Can I then take you to para 184, which is page 2161? European Court sets out there a number of general principles. Where it goes, and these broadly reflect Hashimi, but they do go slightly further in one or two respects. Firstly, if you look at para 184, the European Court expressly said jurisdiction must be considered to reflect the term's meaning in public international law. In a Portuguese case that I will take you to, there's been perhaps some slight softening of that, or slight modification of that, but that demonstrates why I've been focusing on the international law in this context. That is where the European Court. That is then reflected in para 185, which talks about jurisdiction being primarily territorial, and does so in referencing public international law. What the court then does, which we submit reflects the passages I took you to from Bankovic. If you go to just above the lower hole punch in 185, it repeats essentially the approach in Bankovic of making clear that extraterritorial exercise of jurisdiction is defined and limited by the rights of other relevant states. So this is the court, after Alstein, going back to that point from Bankovic, which is the point I was making, which is that an underlying concern here is if you extend the jurisdiction of state A, you run the risk of reducing the jurisdiction of state B, and that's unacceptable in one sense. The court then talks about the need for special features. You see that in para 185. And that what follows is basically in that particular passage Al-Asqaini. What it does do, para 188,
188.
yes, going over the page before it comes to consideration of specific issues, which is important. It does note how physical location of someone isn't effectively determinative. It does that in the context of Article, doesn't use that language, but that's the implication of what it's doing in its consideration of the approach to Article 6. If you look, I think it's about 10 lines up from the bottom of the page 2162, the court says, the sentence starts, if civil proceedings are brought,
Yes, I see.
yes, in domestic courts. The point it's making there is if someone in State A brings proceedings in State B, civil proceedings, State B, unsurprisingly, despite the location of the person, is required, obviously, unsurprising, because it's the jurisdiction of State B to determine how its courts operates. State B is required to ensure compliance with Article 6. So it's an indication which is consistent with what follows, that physical location is not of the person is not necessarily determinative. It depends on the rights in issue. And that's what then...
Could we just understand that?
Yes.
So specific circumstances of a procedural nature have been used to justify the application of the convention.
Yes. One of the reasons for this was that one of the arguments, and I'm going to come on to it, why jurisdiction applied, was that the family said we brought proceedings in French courts about the situation of our family so the European Court accepted that for Article 6 purposes that would be...
Yes, but so I don't understand the relevance of that at all to our case. That again is looking at the word territorial. The proceedings are in your territory.
Yes, but the point I'm making about it is, when looking at, it's ultimately, we submit, also an indication of the fact you need to look at what is an issue in a particular case when looking at what the jurisdiction is. Because so the individual is physically outside the UK, to use this example, assuming it's proceedings in the UK. That's not determinative, because ultimately it's the UK's jurisdiction determining what happens to proceedings that are brought in the UK.
Right, okay.
And that links in. If you then go to 189, and this is the key principle I bring from that, is what the European Court of Para 189 between the two hole punches indicated it hadn't dealt with previously was whether the rights in the convention could be divided and tailored, their language, for the purposes of Article 1. And that's what it ultimately did, because what it did was in relation to each of the rights. It looked at 3 issues. Particularly, it looked at the rights separately in relation to the last of these issues. And you see the issues it looked at as potentially giving rise to jurisdiction. At the bottom of para 190, whether France exercised control over the area, whether there was sufficient jurisdictional link because domestic proceedings had been opened in France, and whether there were sufficient ties through nationality and consular jurisdiction in respect of each of the provisions. In relation to the first of those questions, para 192, it found there was no effective control. So, unsurprisingly, that didn't give rise to a jurisdiction. It found at para 195 that the bringing of proceedings wasn't enough. Obviously, implicit in that, that's why I said the approach to Article 6, in one sense, demonstrates how one needs to consider the rights in issue and what's in issue in a particular case factually. It then looked at the connecting ties, and in relation to Article 3, concluded there was no jurisdiction, and you see that at para 203, where the court concluded that you couldn't claim jurisdiction, essentially because there was no control. It wasn't enough that these people were French nationals. That, we submit, reflects back to the case that I've already also reflect an approach of this court, but it reflects back to, or links back to what I've already said about overlapping rights, because if what is in issue is the conditions of a Syrian camp, which is what was in issue in relation to Article 3, any sort of assertion by France over those camps would inevitably, because of where they were located, restrict the jurisdiction of Syria, which would primarily be responsible for what was happening on its territory.
I'm sorry, I don't think that's the point. I think the point is what were the factual circumstances? It wasn't an issue of law, and the decision was that the French authorities did not have control.
Yes. Within
the meaning of this case law. It's not. I mean, obviously, the convention has to fit within the general framework of international law.
Yes.
But I think you're trying to put the cart before the horse. So that this says they didn't have control. As a matter of fact, that's it. It wasn't saying, because if they did have control, it would conflict with the Syrian state. If they had control, they had control. That might conflict. Doesn't matter. Wouldn't matter. If they were actually exercising effective control through their state agents, then they might be liable for a breach of convention rights.
Well, I would certainly say implicit, one of the problems that you had from an Article 3 point of view was the point I was making about conflicting responsibilities. But I accept that's not expressly said here, but it links in because what happens, and I'm just about to take you to it, is a different conclusion is reached in relation to the claim based on Article 3.2 of Protocol number 4, which is the right of entry. And the approach to the right of entry is that was found to be within jurisdiction.
Only because of the facts of the case.
On the facts of the case, but it was on the facts of the case because, in particular, there was a need for Article 3.2 to be effective, and you see that para 208 and 209. If the court's conclusion was that if Article 3.2 required you to be at a border so that you were physically within the jurisdiction of France, that undermined the effectiveness of the provision. And so what the European Court was saying was you have to read the convention as a whole. You have to read it in a way, as I say, it's 208 and 209 in particular. You have to read it in a way that in particular ensures the protection of human rights is effective.
No, what it's saying is that Article 3, well, the article set out in 204 would be meaningless if it only applied to people who were already in the territory of the relevant state, because then it would have no substantive meaning at all. That's what 208 and 209 say. So it's not a general point about the application of convention rights outside the territory of the state. It's a specific.
But if you go back to 208, what the European Court is saying is that when interpreting jurisdiction, you have to interpret the convention as a whole.
That is standard wording that once he's repeated. Of course, you have to interpret it as a whole. Of course, you have that the rights have to be effective. But the specific reasoning in respect of this provision is that it wouldn't make sense if it only applied to people within because they're already there, so it would have no meaning.
But the more general principle, I accept, obviously, factually, it is significantly different, and I've already accepted there is a case directly on point. The point I'm making is the 2 points I'm making. Firstly, the different, and this is perhaps the first, probably the most important issue of principle that comes from it, was that when you look at the issues of jurisdiction, they are not simply determined by where the potential victims are located. They are determined to a significant degree on the basis of looking at what the nature of the complaint is and what issues then arise. What are if you like the factual circumstances that are said to amount to a violation, and they were different effectively in relation to Article 3. The focus was on the complaint in Syria. In relation to Article 3.2 of Protocol 4, the complaint was about entry into France and rights effectively to re-entry.
Just to be clear, when you say facts, is it facts or is it rather the particular right that's being invoked, which is Article 3 of the Fourth Protocol?
Well, it's both, I would submit, in the sense that what you see there in my submission is that the nature of the right means that different factual matters are relevant, and that's why. So it's starting in one sense from the article, but it then has consequences in terms of what the factual issues are and how they potentially come within jurisdiction.
I follow that. I mean, obviously,
passages 212 to 213. That's why they decided it the way that they did. It's because this case was dealing not with Article 1, which deals with anybody, whether they're a national or not. Dealing with Article 3 of Protocol 4, which only applies to nationals of the state that you're making the claim against. Then, as my lord has said, physical presence doesn't determine it because you're talking about a right of entry, and if you're somewhere outside the state, you've got to be outside the state in order to have it be denied a right of entry. Then it was said, well, there may be certain circumstances relating to the individuals who wish to enter the state, which might give rise to a jurisdictional link, and you've got to look at it on a case-by-case basis. We're not going, says the state, says the court at the end of 212, to give you an absolutely exhaustive list, but looking at the facts of this case on 213, we think there's enough of a link.
Yeah,
and that's what they decided.
But what I'm trying to do, and I submit it's legitimate to do this, is draw from it the principles that it applied when concluding that that on the facts there was something within jurisdiction. And the two principles I draw from it are, firstly, physical location isn't enough. You've got to look at what the nature of the right in issue is and what facts are relevant to the determination of the right in issue. And secondly, the principle of effectiveness, which I recognise is a well-recognised principle, is relevant to jurisdiction. Because that's the basis upon which the court said, ultimately, you can't say you have to be in the country to enjoy this, in the state to enjoy these rights. Because if you impose that requirement, it would make the provision pointless, effective, and meaningless.
Okay, and anything else in HF?
No, thanks. two other authorities that I should just reference partly to deal with arguments that are put against me. One is MN versus Belgium, tab 52, page page 179. I may have got the one page wrong. Sorry, it's
It starts at 1768. if
yes.
that's any
So
help.
the relevant passage I just need to address is at 1793. 112. That is the statement, the mere fact that decisions taken at national level had an impact on the situation of persons resident abroad is not sufficient to establish jurisdiction. I don't dispute that as a matter of principle. Question is, as HF demonstrates in our submission, what is it that's specifically being raised, and whether that in particular comes within the consular access, as it comes within rather the jurisdiction of the state whose actions are being challenged. The second authority that I should take too briefly because it's relied on by my learned friends is Agostino versus Portugal, which is in tab 56, page 2262, I think, is the relevant passage, where the relevant passage starts. In my submission, it is
Sorry, can you give me the page again?
2262.
Thank you.
Just a word of caution in my submission about it, because it is a case where there was a fairly ambitious attempt in our submission to impose obligations in relation to climate change on states in circumstances where the complaint was being brought by residents of other states. A case where the argument essentially was, as I understand it, that as a resident of state A, I can complain about the actions of state B in relation to climate change. That's why the European Court at para 199 indicated that it was significant that there'd been no particular link to the respondent state. That reflects something that one sees in my submission in domestic courts, which is the concern effectively about the convention being used in a way that would impose global obligations on members of the Council of Europe. What is also said, and this is the reason I wanted more directly, the reason I wanted to address it, is para 205, the court indicates that what has to be an issue is control over the person rather than the person's interests. That is a test that in our submission is not necessarily easy to apply. An HF is an example of that. And if you think about HF, in one sense, it's pretty clear that there was no overall control of the persons whose rights were an issue because they were in a Syrian refugee camp.
But HF was not dealing with Article 1. HF was dealing with Article 3 of Protocol 4.
Well, sorry,
This is all about Article 1 and control and the test which has been applied in Bankovitz and the whole line of cases. You can't interpose arguments that come from questions of what happens with one's nationals wherever they happen to be situated all around the world, which is what HF was dealing with, and what is being said in Agostino, which is pretty orthodox application of established principle that in order to have extraterritorial jurisdiction over an individual who is not a national under Article 1, because it applies to everybody, there must be a link, and the link is control.
But maybe, sorry, I think I missed responding to that same point when, and I apologise for this, when you questioned me about HF. I don't. The passage I took you to was in HF was specifically in the context of a consideration of jurisdiction, because the argument that was being put by France was we have nothing to do, we have no jurisdiction in relation to these people given their location, and that's where the distinction was drawn. Article 3, the argument was accepted, but the court went on to consider separately, because of the nature of what was involved, the article, I think it's Article 3.2, isn't it, of Protocol number 4. They considered that separately, but it's still in the context of an argument that the location of the individuals meant this was outside France's jurisdiction.
What the court says here in 172 when dealing with HF is that the court in HF considered it important to differentiate between, on one hand, Article 3, and on the other hand, Article 3.2 of Protocol number 4, in respect of which it established jurisdiction having regard to the very particular nature of that provision. So it's focusing on the nature of Article 3.2 of Protocol 4.
Yes. So, which is consistent in my submission with my submissions. What I was saying was the argument was about jurisdiction, and the European Court recognised essentially that you needed a different approach to jurisdiction in the context of Article 3.2 of Protocol 4.
But you're not, are you, going so far as to say that there is anything particular about Article 8 or indeed Article 14 dictating a different approach? Or are you saying
I am saying there's a distinction between Article 8 and Article 14, and I'm going to come on to that. And Article 14, what I'm saying is that when you look at the issue of what is in issue in Article 14, it links back to what was said in HF about nationality and what's been said domestically by the Northern Irish Court of Appeal about nationality. Nationality is concerned with the bond between an individual and the state. And that bond, the nature of that is something that's within the jurisdiction of the state as a matter of international law. And that's the distinction.
But is that not a different point? What's being said here is, well, if you look at Article 3.2 of Protocol 4, it makes no sense for that particular provision to be tied in the way that was being suggested in HF. And you can't find anything comparable in Article 14, can you, in Article 14 itself?
There's nothing, but the language of Article 3.2 isn't necessarily determinative, because if you look at, for example, what they said in HF about Article 6, the proceedings that have been brought in France, even though they weren't enough to give rise to jurisdiction in relation to other matters, presumably did give rise to jurisdiction in relation to Article 6.
I mean, of course, there you're dealing with something that is happening within the jurisdiction, and two people within the jurisdiction, or I mean, the litigants who are litigating in the jurisdiction.
But it's an indication of physical location. I mean, what I goes back to what I'm saying about you need to, in my submission, consider the nature of what the right is, and as a result, what facts are relevant and what the jurisdiction is in relation to those facts. And it goes back to why I said the nature of nationality is a bond between the individual and the state that they're a national of, and that is within the state's jurisdiction to determine whether that bond is sufficient, and that is within the jurisdiction, despite the first person's location. That's the point. That's at the heart of our argument, basically, and that's the point we're making about this. Is that you can't, and it goes. The reason I was, in one sense, making that point in relation to control. If you think about HF, what is said in about control in para 205, To use the example, I won't use the HSF example, but use the Article 6 example. If someone is in a northern Syrian refugee prison camp and they bring proceedings in the UK doesn't have control over them for most purposes, but it does have control over how those proceedings are conducted, and that must be sufficient, effectively.
Can we just look back then to see why Article 6 was
Yes.
in play?
Well, Article 6, to be fair,
We didn't quite look at the reasons. It's in 188 participate chair.
Proceedings were in.
Sorry, Article 6, can I just be clear? Article 6 wasn't directly in issue in the sense that there wasn't an Article 6 complaint. Article 6 was considered, if I remember rightly, because there was an argument that it was sufficient that there were proceedings in France to bring the two.
And they say that's not good enough.
They say that's not good enough.
But just to understand, we didn't really look at the reason for it being accepted that compliance with Article 6 was needed. And is that in the middle of 188?
188 is where the court addresses the issue.
So even though the extraterritorial nature of the events alleged to have been at the origin of the action may have been an effect on the applicability of Article 6 and the final outcome of the proceedings, it cannot under any circumstances affect the jurisdiction, ratione loci and ratione personae of the state concerned. If civil proceedings are brought in the domestic courts, the state is required by Article 1 to secure in those proceedings respect for the rights protected. So how does this work?
Sorry, well, as I understand it, what it is saying, effectively, is the fact that you are located in Syria doesn't mean that if you have proceedings, there isn't something that's within jurisdiction, that there is a jurisdictional link, because, unsurprisingly, the state where you've brought proceedings has control over those proceedings. It is its jurisdiction to determine how they're conducted.
If anybody, anywhere in the world, brings proceedings within a particular territory, which is a convention territory, there is an obligation to act fairly.
Yes, absolutely.
In relation to those proceedings, and that's all that this is saying. It's saying the ratione loci, which is the place where it happens, and again, personal jurisdiction over the individuals aren't affected in any way by the fact that the proceedings relate to something that happened outside those the jurisdiction. So, provided that the state concerned has domestic jurisdiction to entertain a claim about something that happened in France or Syria or somewhere else, then there's an obligation to afford to the litigants all the rights and obligations under Article 6 and act fairly. But that's because it's all happening in the territory of the state concerned. We're not dealing with something that's happening within the territory of the state concerned.
Well, we're dealing with, and it goes back to what I'm saying about the nature of the issue, we're dealing with a situation where what the state is doing is deciding whether the nature of the bond between the appellant and it is sufficient to justify the grant of British overseas citizenship. And that is a matter that, in one sense, it's pretty difficult to pin down where that is, but it is a matter that is ultimately within the jurisdiction of the United Kingdom.
I'm slightly worried about the time because you keep saying.
I have an agreement with my learned friend. I think that I would go for 2.25 hours, and my learned friend would go for 2.25 hours.
Okay.
And so I am conscious of the times, and so and a half an hour response. I think it was on the basis that it was a
Wait a
full
minute.
day.
Is my maths right? 2.25 and 2.25.5.
Yes, makes it 5 hours for 4:30. I think.
Okay.
My lord, if my lord wants me to, I am trying to speed up.
Okay,
Anyway. I'm conscious.
good.
I have
I get deflected by questions.
You do.
from
You
people
have.
like
We
you.
have asked you a lot. So well.
No.
Keep quiet.
No,
So you've dealt with paragraph 205 of Agostini.
yes. Can I just also draw attention to one other paragraph of Agostini, because it's linked into the next stage in my argument, which is at 226.
Paragraph 226.
No, it's page 2264.
Oh, okay.
And it's para 209.
Yes.
And there you see what is the, in one sense, the latest statement on, certainly as far as I'm aware, of the approach essentially to the relationship between jurisdiction and international law, which is a repeat of what's been said before, which is that it needs to reflect the meaning of public international law. But, and this doesn't really arise on the facts of this case, because I don't think, because, but equally, jurisdiction of other conventions and other treaties may be may have different scope.
Yes, thank you.
Now, my Lord, the reason I just drew attention to that is that the next stage in our argument, we say ultimately jurisdiction it has to reflect international law, and as I said previously, we argue that it's the United Kingdom and only the United Kingdom to decide who are its citizens or who are its who has.
I'm sorry, I read 209 as to being to precisely opposite effect. Is that, in other words, what is being addressed is the convention. The convention has to be interpreted in a way which is harmonious in the context of public international law, but other elements of public international law don't bind the interpretations to be given to the provisions of the convention. So you seem to be saying that when you say jurisdiction has to reflect international law, can you elucidate that a little bit?
Yes. What
more broadly?
Yes. What I was trying to say, probably rushing, was that I mean the language of the European Court is in fact reflect, and that was the language that was found previously. What I understand that to mean is if international law provides that State A has jurisdiction for a particular matter, then in general, Article 1 of the Convention has to reflect that, because the language used is simply that of jurisdiction. That doesn't necessarily mean that jurisdiction in the context of Article 1 will be the same as jurisdiction in other provisions of international law, because they may use different language. That's what I understand this sentence to mean, but
okay.
Because it's the first bit before CU.
Anyway, okay, that's what you say.
Yes.
So, yeah.
And as far as I know, I mean, obviously, there's probably not much more I can say about it, but that is, as far as I'm aware, the latest statement of the court on the relevance of international law, whatever one makes of it. Well, with international law, we submit is pretty clear that nationality, unsurprisingly, is for the state that is bestowing international law to determine who its nationals are. If authority is needed for it, and given time, I might just give you the reference, because I'm not sure this is seriously in dispute. It is, I'm going to massacre the pronunciation of this, Camoini Shunigan, which is Northern Irish Court of Appeal, tab 1, volume 1, tab 29, page 832, para 75. One thing I would just emphasise, it links in with the point I was making about Article 14 and where Article 14 comes into play, which is it makes it clear that or it cites rather the European Convention on Nationality as defining nationality as being a legal bond between the person and the state. Again, in one sense, for speed, I've already made clear that one of the reasons why the applicant is particularly keen on overseas citizenship is because it would give her rights to consular access, and the basis for that is the Vienna Convention, and I'll give you again the reference. It's Article 36(1) of the Vienna Convention, which is in Volume 1, Tab 9, page 39. And all of that, and the reason that's important is because it demonstrates why, in one sense, it must be for each state to determine who are certain nationals. If that weren't the case, if a receiving state of a consular agent could say, we're not going to recognise the citizenship of this individual, it could undermine the rights that exist in relation to consular access. Third authority I'm going to give a reference to again to move on. Quickly, this is a judgment of the Court of Justice of the European Union, which is in Volume 2, tab 37, page 1126 rather, 1126. Micheletti, para 10 rather, paragraph 10, where it said that international law provides for each state to lay down the conditions of acquisition, and as a result, other states can't restrict the effects of granted citizenship. That, I accept, is a judgment of the CJU, but it's applying international law. It's not on the face of it simply about EU law.
Yes.
Now, why does all of that matter? This is where the specific issues in relation to Article 14 arise. Article 14 is clear, or the case law in relation to Article 14 is clear, that because it is ambit that engages Article 14, what is potentially in issue is rights that go beyond those required to, as a matter of international, as a matter of convention law. So, can I take you to the citation I rely on in relation to that? It's Volume 2, tab 39, page 1156. Step. And we know a benefits case.
Sorry, which page again?
1156.
Yes.
Para 39. And it's what the European Court, it's really the second sentence that I emphasise, which is, and this is why ambit is the test effectively for engagement, is that Article 14 is concerned with additional rights falling within the general scope for which the state has voluntarily decided to provide. So, in the context of benefits, and this is relevant for nationality and a reason that we're going to go into in a moment, the state generally doesn't have to do very much in terms of providing benefits as a human right. There's not very much in the way of human rights to a benefit. But if a state does then provide benefits, even though it's going beyond the convention, that is likely to engage Article 14 and can't happen in a discriminatory manner.
Yes.
In the context of nationality, because it's for the state effectively to define what bond is sufficient to amount to sufficient to generate nationality, it's very difficult. There are perhaps limited circumstances where it's possible, but it's very difficult to bring a claim arguing that denial of nationality is a breach of Article 8, which is where it would normally fit, but breach of any substantive right.
It's impossible necessarily to argue it's a breach of Article 8.
Well, certainly deprivation potentially brings it into that scope. There may be, I accept, there may be a distinction between grant of citizenship and deprivation.
Deprivation might, but
yeah,
deprivation is more likely to engage a host of other articles as well.
Yeah, but my lady, the reason I make that point is that it is recognised that Article 14 is potentially engaged by citizenship, and there's a logic to that, which is states can decide whether or not particular ties are sufficient. But if you say that those ties are only sufficient in the case of a man, or only sufficient in the case of someone who's white, you can understand why there's an immediate human rights issue in the context of that.
falling within the general scope of any convention
It's
article.
falling within the general scope because it's about. Can
So
I just take
which scope, which convention article?
Article 8 is the one that's recognised. Can I take you to Genovese, which is the leading Strasbourg authority, but it has been applied by the Supreme Court.
Sorry, before
Genovese
you
is
take
volume
us to
2.
Genovese, sorry to interrupt you, but I'm just trying to get my head around this argument and make sure I understand it. You've taken us to Steck, which confirms that Article 14 doesn't have independent existence, but only applies if there is the facts of the case fall within the ambit of another article.
Yes.
You then said that because that engaged questions of benefits, which potentially fell within Article 1, Protocol 1, there's some kind of an analogy that you want to draw between that, because the state is responsible for deciding who gets benefits. You say, well, you can run an analogy with that because the state is also responsible for deciding who its nationals should be. Is that right?
Yes. I mean, I would.
I'm just trying to get my head around the argument at the moment. But as I understand it, you say the state's responsible for deciding who gets benefits. That potentially engages convention rights. States also responsible, international law, domestic law, for deciding who its nationals should be. That's also potentially capable of engaging convention rights, even though the denial of nationality would never in a million years fall within Article 8.
Yes, the reason I slightly hesitated was, in one sense, I don't need the analogy. The point I'm trying to make is I rely on it really to explain what is the approach that then is subsequently adopted in relation to citizenship, where Article 14 is held to apply because effectively it is an additional benefit, and we say that's effectively because it is an additional benefit that is within the general scope. And it's a general benefit that although you have as a state a wide margin, a very wide margin of discretion, ultimately you can't do it in a discriminatory manner.
And just to be clear, this is within the ambit of Article 1 of the first protocol.
Yes.
You say we're within the ambit of Article 8.
Okay, yeah, look, it may help if I take you specifically to Genovese,
Yes.
which is the case on point.
Yes.
All I'm doing is, in one sense, putting that in context to explain why Article 14 is different, because it's a clear statement of the principle. It's not my best authority on why Article 8 is engaged, and there is a specific case engaged.
Yes.
The lead authority is Genovese, which is it starts at Volume 2, Tab 4, page 1320. And it was a case to do with, which is what the domestic case of Johnson, which I'm going to take you to, which endorses this, is about. And it was a case where effectively there was a denial of citizenship, and it was based on illegitimacy of the relationship between, or the fact that the child rather was born out of wedlock is a better way of putting it, and father's refusal to reflect the son's paternity. Now, it should be noted, and I accept this doesn't take me very much further, and this court has noted this, that it was a case where jurisdiction was effectively apparently accepted, admittedly entirely without argument, without any reasoning, in circumstances where the son, the person claiming Maltese citizenship, appears to have been outside the outside Malta, and you see that from para 10 of the judgment. The key point, that's not really why I'm taking you to it. The key point I'm taking you to it is because of the reasoning as to why Article 14 comes into play. And if you go to Genovese at para 30, you will see the court indicating, consistent with what my lady has been putting to me, that Article 8 doesn't guarantee a right to a particular citizenship. What the European Court then goes on to say at para 33 is while there isn't a violation of Article 8, impact on social identity, court's language, not mine, was sufficient to bring the matter within the ambit. Now, social identity, we would submit, is another way of talking about the bond, effectively, between the individual and the state. And it's also an example of, goes back to the point I was making about Steg. The state didn't have to give anyone necessarily citizenship, but if it was going to do it, give certain groups of people, it couldn't do it on a discriminatory basis. In fact, a violation of Article 14 was found. Now that's been directly applied by the Supreme Court. If you go to Volume 1, tab 20, page 528. Para 27. You'll see Genevieve being cited at para 25, a similar Slovenian case and some other cases being cited. But Supreme Court effectively using pretty much the same language as the European Court of Human Rights. So it focuses on that issue of social identity, essentially. So what I'm saying in relation to this is that it links back to what I said about HF, the need to consider the article, and what are the issues in this. In the context of an Article 14 case, Article 8 cases are different, because then you are looking at things like private life. But in the context of an Article 14 case, what matters is this bond, social identity. We say they're related concepts. That bond between the individual and the state, concepts that the location of that is pinned down, but that is clearly within the jurisdiction of the state where nationality is an issue. And all of that needs to be considered.
Sorry, clearly within the jurisdiction of the state where nationality is at issue. What does that mean?
What I mean, to be very specific about the facts of this case, it is for the UK to decide whether the bond between the appellant and the United Kingdom is sufficient as a matter of law to entitle her to overseas citizenship. It's not for any other state. And that links in some senses back to the point I was making earlier about HF and the need to ensure effectiveness. If you think about HF and the facts of that case, the physical location in Syria meant that there was a state that was responsible for ensuring human rights in relation to the prison camps. May not have been a very functioning state, may not have been a very effective state, but it was a state.
And not one that was bound by the European Convention.
Not one that was bound by the European Convention, but that's inevitable in a regional instrument.
That wasn't the basis of the decision. The basis of the decision was the French authorities did not have control. It wasn't because another state has responsibility for what happens.
I accept that, but my lord, but it's still an underlying, we would say on its facts, an underlying feature of what happened and why one of the difficulties in arguing about that. The point in comparison, the issue of the French borders and whether or not readmission should be permitted, essentially, and that was something that clearly only France had responsibility for. And if France couldn't be responsible for that, no state would have any responsibility as a matter of international law. Here, if the United Kingdom isn't responsible for ensuring that it operates overseas citizenship in a non-discriminatory manner, no state would be responsible for that.
But, sorry, you took us to Agostini before, and Agostini said that there is no support in the case law for a criterion such as control over convention interests as a basis for extraterritorial jurisdiction. And speaking for myself, your argument seems to be that if there is a convention interest for which the state is responsible, then there is jurisdiction, even though it is, in fact, extraterritorial jurisdiction. So, in other words, your submission seems to say, speaking for myself, seems to go contrary to that principle.
Well, I don't accept that for this reason. Agostini, what effectively was being argued was that not only potentially was the state where the applicants were located subject to responsibilities in relation to climate change, it was a range of it was another state as well that was potentially liable, and so there wasn't an issue about the effectiveness, and there wasn't an issue with a gap. The question was it sufficient that the other state, the state that where the individuals were not located, had the potential to take decisions that impacted on the convention rights of the individuals. Here, I'm putting my argument narrower, which I submit reflects the importance of effectiveness as identified in HF, and saying it's not simply that the UK has the potential of taking a decision that might interfere with Article 14 rights, assuming they're within jurisdiction. I'm making the point that if the United Kingdom isn't treated as having jurisdiction in relation to those rights, there is no other state that has jurisdiction. That's it.
There's a sort of slight shift, I feel. With Article 3.2 of Protocol 4,
yeah,
they were able to say, well, look, this convention provision won't be effective unless we understand it in a particular way.
Yes.
But you can't say the same about Article 14, can you? I mean,
well,
true it is, Article 14 will be more effective if you operate it around the world for everybody. But that's not the test.
Well, that's, I'm certainly not saying, I'm trying to avoid saying, I hope I'm not saying, that Article 14 should be applied around the world, or that effectiveness requires it to be applied around the world. The point I'm making is that you have, and in one sense, there was perhaps an additional aspect of this argument I needed to come to, which I should make now, because it may help in understanding what I'm trying to say about effectiveness. I have to accept, that Article 14 is not made meaningless, essentially, or without effect, if my arguments are wrong, and I accept that's the distinction between this case and HF. However, what Article 14 is concerned with, see STEC, is where a state bestows additional rights. It has to do it in a discriminatory manner. If you think about issues in relation to citizenship, quite often with those issues, the person who is claiming some form of citizenship will be outside of the United Kingdom, or will be outside the state whose nationality is an issue. And that's because although I accept British overseas citizenship isn't a form of citizenship, oddly, that gives rise to rights of residence. Normally they do. So if a state decides, not because it's obliged by the convention to do this, but because as a matter of its discretion, it wants to bestow the benefits of citizenship on a particular group, but does it in a discriminatory manner, the reality is that limit that right effectively to people physically within the United Kingdom. Not only does it not reflect the nature of what's an issue, which is the assessment by the state of the bond, but it also potentially undermines the effectiveness of the protection, because many of the people who would want to rely on it in relation to citizenship see on the facts Genovese, who was outside of Malta, will simply be unable to benefit from it. And so the effectiveness argument, I accept, is not just a complete, it's not a wipe out of Article 14, but there is still an effectiveness argument. That's the point to make.
Okay, thank you. Yes.
Well, that then means, and I've probably just about got time to do this before 12:45. That then means I should probably review, just take you to the sort of key domestic authorities. And obviously, what I'm taking you to them rather to argue that they are distinguishable. Probably the key authority is R3, which is in Volume 2, Tab 31, page 919.
Yes.
919 is where the relevant passage is, and the issue there was a breach of Article 8. Obviously, you see that from paragraph 102, Roman 2. 103 states the principle that, the first sentence of that states the principle that I accepted, we've always accepted, but this is the authority for that effectively, which is you apply the decisions of the European Court of Rights. I don't think there's any controversy about that. What 103 though does, which is perhaps more significant because it links back to what also probably is not in dispute, which you need to consider the facts, is it makes clear that there had been no decision where someone, and the facts identified as relevant are these, had left the United Kingdom voluntarily, who was a dual national and who was living in a family unit outside of the United Kingdom. Consider the application of that set of facts essentially to jurisdiction. Two things that then the court identified. Look at para 105. The court said it needed to apply S1, and I'll come to this one. S1 is an Article 3 case, but it again had similar facts. And secondly, it addressed an argument about the fact that there was family in the United Kingdom. It does that at para 106. But indicated, and this is probably the more important factor in terms of sort of, I mean, it's perhaps always easy to point to factual distinctions, but this is an issue of perhaps some principles. It underlies the distinction I draw between Article 8 and Article 14. It makes the point that although the family in the United Kingdom might be relevant at some time in the future, that was only going to be if the individual applied for entry clearance. And that's a critical feature of the case law regarding citizenship, particularly deprivation of citizenship, because that's generally where it's arisen, and Article 8. If you think about deprivation of someone who is a citizenship active outside the United Kingdom, one of the effects of that, or the first effect is, it is the United Kingdom saying that the legal bond is no longer sufficient. Genovese says that's not on its own sufficient to engage Article 8 effectively, because that, if it had, that case would have been dealt with under Article 8, not Article 14. Now, obviously, someone who's got citizenship may have had private life, family life arguments about the United Kingdom. But of course, the deprivation of citizenship doesn't necessarily mean that the person can't come back and enjoy those rights. And so, the underlying facts giving rise to jurisdiction cause problems, basically. You don't have the same sort of issues, potentially, about matters within the jurisdiction of the United Kingdom that arise directly from the deprivation of citizenship. Of course, if the individual does apply for entry clearance, Article 8 might come into play, and that's been repeatedly recognised in the cases. Because that is something within the jurisdiction of the United Kingdom. It's within the jurisdiction of the United Kingdom to decide whether someone should be admitted so that they can enjoy their family life. S1 was considered, sorry, S1 is also in the bundle. S1, as you've seen, is the basis for the decision. And S1 is at Volume 1, Tab 19, page 503. And he was someone, you see this by the first hole punch. It's the last sentence, the last, yes, it's by the hole punch, it's just above the quote. He was someone who had settled in Pakistan.
Sorry, which page are you on?
Sorry, 503.
503.
Yeah. He was someone who had settled in Pakistan, but despite that was arguing effectively that he could rely on Articles 2 and 3. This was perhaps before, it was before HF, which probably been a fatal blow to his arguments. In any event, what the Court of Appeal relied on, this is obviously in relation, this is obviously the basis, as I say, of the approach in R3. It relied upon, in particular, case Khan in the United Kingdom. You see the reference to that, para 93. And the concern of the European Court was, if you go on to page para 96, para 26, and this was effectively upheld by the Court of Appeal in S1. It's the quotation of citation rather of para 26 and para 96. And the concern was you couldn't really distinguish between someone who departed voluntarily and someone who'd never been in the jurisdiction. And if you, and then in light of that, it then went on in the passage cited at para 97 to express a concern that there was an unlimited obligation to admit. Now that, in the context of R3, was obviously an important issue, because R3, what one can say about R3 in my submission is R3 was someone who again had left voluntarily. Should he be in a better right than someone who'd never been to the United Kingdom? No. Did that mean that he could never advance his Article 8 rights? Of course, he could advance his Article 8 rights because he could apply to be readmitted without necessarily being a national. But did his citizenship deprivation give rise to any rights in the United Kingdom? Not on the face of it, and that's partly reflection also of what's engaged in the what's human rights are potentially engaged in the context of citizenship, and say they are primarily not Article 8 rights. So what all of this case law demonstrates in my submission is, and it's consistent with what I said about HF in particular, that when looking at jurisdiction, one needs to look at the rights in issue, one needs to look at the facts that are relevant to those rights, what the Court of Appeal was doing in both of these cases was looking at specific facts and how they engaged human rights, or arguably engaged human rights. And that is what I've sought to do in my submissions about Article 14 and nationality.
SI is dead against you on that point, because they tried an Article 14 read with Article 8 argument based on Genovese. SIAC said, sorry, that doesn't help you, and paragraph 99 on page 506 says Genovese didn't engage with the Article 1 arguments, anyway, it wasn't clear whether the child was in Malta or had rights to be in Malta under free movement, and SIAC concluded the case did not support the appellants in my judgment were right to do so. So isn't SI a complete answer to Genovese?
No, maybe in my submission, because it's not, as far as I'm aware, an article. Genovese was relied upon as support for an argument that there was jurisdiction for the purposes of Article 3 or Article 8. It wasn't, I don't think.
There is an Article 14 claim, as I read it.
I'm not sure. I haven't spotted that. I'm always very conscious of saying the worst thing for a lawyer, in my opinion, is if you look
Well, Article 14 certainly mentioned at the bottom of paragraph 91, but I think I picked it up earlier. Ah, yes, here we are. It's paragraph 58, page 496, sub-paragraph 2. So these were the issues that had been identified for SIAC to resolve, and it was said under little 2, Roman 2, if contrary to the above statutory provisions, they do permit a British citizen to be deprived of their legal status in the UK, etc., etc., this is unlawful discrimination by reason of nationality, contrary to the right to equal treatment under Article 12 or Articles 8 and 14. So they were running an Article 14.
Well, they were running an Article 14. They may have been running an Article 14 argument before SIAC. What I was focused on was before the Court of Appeal. I don't understand them. If you look at Para 5, which is where I was looking, if you look at Para 5, which is the issues for the Court of Appeal, Roman 4 is it outside for the purposes of Article 1 in relation to Articles 2 and 3. Then Roman 6, Article 8. And so in relation to both of those issues, you see Para 103, consideration of substantive Article 3 rights, 108, consideration of Article 8 rights.
So you think they might have dropped the Article 14 argument?
Well, on the face of it, yes, that seems pretty clear, because the issues on the appeal were Article 3 and Article 8, and the reference. I've not seen either in the consideration of jurisdiction or when it then goes on to substantive rights, any engagement by the Court of Appeal with Article 14.
Okay, thank you.
My lady, my lord, only rising case that assists on this very specific point. If one turns over the page at 497, paragraph 59, it says issue 2 and 3 have not been pursued in the second.
Yes.
I think that might be the answer.
Thank you.
Thank you, thank you.
Thanks very much.
Thank you. Can I just turn around? I just wanted to check one thing very briefly.
Of
but I know
course.
it's exactly on time. Lord, I think in terms of the issue of remittal, that's the primary thing I wanted to check.
Yes.
I'm not. We set out our case, so there's nothing more I can say.
Right, thank you.
Not least because I'm conscious of time.
Yeah, thank you very much. Anything else? No. Yes.
My lady, my lords, I'm grateful. If it assists the court, I was proposing to take things in 3 stages in my submissions, and given the questions from the court so far, I'll take those more quickly than I would otherwise have done. I should be able to do it hopefully by about 3 o'clock this afternoon.
Good, thank you.
The 3 stages I was proposing are as follows. First of all, some very short points of context, factual context, to frame the legal submissions I will make. That's critical because, of course, any Article 1 decision turns on the facts as the cases show. Secondly, to look at some of the case law, but only a limited amount of it, is on the established approach to jurisdiction under Article 1. And can I just headline now? I'll go very briefly to Bankovic and Al-Skeni, but only very briefly because you've seen them in such detail already, to draw out 1 or 2 particular points of distinction with my learned friend. But this case, I say, turns really on MN and Agostinho. Those are the 2 cases I'll spend some more time on. You've seen Agostinho, you haven't seen much of MN, and it's actually absolutely determinative, we say, on this point. I'll explain why in due course. And then thirdly, I'll respond to some of the specific arguments advanced by my learned friend, take you back to 1 or 2 of the cases you've already seen. I won't say anything then in those circumstances, given the indication from the court about Article 14 and given the learned friend's approach. I won't say any more about that now. If the court is against me on Article 1, then I understand that the approach is going to be remittal, which we would agree with. Respectfully. Can I then just introduce my contextual points with the Secretary of State's case in a nutshell? And it really is this. First of all, jurisdiction is primarily territorial under Article 1. Secondly, extraterritorial jurisdiction is exceptional, and the court has taken great and conspicuous care to provide limited examples of where that case law, where that extraterritorial jurisdiction will arise, and the examples are closely defined. Thirdly, the present case, we respectfully say, doesn't come close to any of them. And essentially, what my learned friend's case in submissions this morning has boiled down to is precisely a submission about a doctrine of effects, which the court, from Bankovic all the way through to Agostinho, has ruled consistently does not exist in relation to Article 1. And that's why I'm going to focus on MN and Agostinho in due course. So can I turn then to part 1, the contextual submissions? I won't take you to any of the case law which says now why the facts are so important in any Article 1 case, but it's essentially a question of applying the well-established principles to the facts as they apply in a given case. We say the context here is set by 5 key features. First of all, and I don't think there's any controversy about any of this, the appellant is not a citizen of the United Kingdom, nor does she have any of the various other statuses of citizenship that might exist. Secondly, she has not at any stage resided in or visited the United Kingdom. Thirdly, she has no relatives in the United Kingdom and no possessions in the United Kingdom. Fourthly, She has no desire to visit or work the United Kingdom. And the friends touched on the reasons why she wishes to have British overseas citizenship, but it's not to come here or work here or anything of that nature. And fifthly, this is not a case where, for example, by contrast with many of the Strasbourg cases, she has been detained, questioned, stopped, or in any way affected by any actions of any UK authority operating externally to the United Kingdom. We say that, and I should say, those 5 features are in effect the essence of what the judge identified in this case at paragraph 85. You haven't seen the judge's judgment, and partly for the reason the arguments advanced on appeal are different from those she was dealing with. But it may just be worth turning this up to this limited extent. Paragraph 85 is in the core bundle at page 83. And right in the middle of the page, the court will see applying the authority, so she's been taken to the relevant authorities on jurisdiction. I've concluded that the jurisdictional threshold has not been met. The claimant has at all times resided outside the UK. She was outside its territory when the challenge decision was made. She has no family or private life in the UK. And she will not secure a right of abode, even if a BOC passport were to be issued to her. The impact of the decision upon her private life, employment, visas, travel, is and always will be entirely outside the UK. So it's exactly the point the judge makes. She, in fact, takes it one step further and makes the entirely legally correct point that even if the claimant were to be successful, she wouldn't have a right of abode. A right of abode did not generally follow for those with British overseas citizenship. It was only for a very limited subcategory, which would not include her. So there is absolutely no connection with the United Kingdom, save, of course, for the historic fact of her mother's CUKC and later BOC citizenship. The reason why those points in that submission, I say, is important is because, again, when pressed, my learned friend says, well, this case is about nationality. Nationality is about the bond that exists between an individual and a particular state, which is greater than the bond that exists with any other state of which one is a national. And he makes reference to the well-known Notabone case and to the other authorities. Well, that, of course, is right, but it does not help him because, in fact, there is no connection with the United Kingdom here. So even if one is looking at nationality as some form of connection with the UK to try to establish jurisdiction under Article 1, it's of no assistance, we say, whatsoever. So that's what I wanted to say very briefly on part 1, the contextual background to the legal submissions. Against that background, can I move straight into part 2, which is the case law, the classic case law on establishing jurisdiction under what Article 1. And what I wanted to do was to take this in 2 stages. First of all, to take you back to Bankovic and Alskany very briefly, as I say, and then move on to MN and Agostino in particular. So can I begin by Bankovic?
Sorry, can you remind me where it is?
Yes, of course. It's volume 2, tab 38, beginning
Thank you.
at 1129. My lady in argument indicated this is a case about the bombing of Yugoslavia not being within the jurisdiction. Well, that's absolutely right. The applicants in the case were either the survivor in one case or the relatives of a number of people who were killed in a NATO airstrike on a television tower in Belgrade during the Kosovo conflict. One sees those essential facts from paragraph 7 to 9 at page 1130.
Yes.
So in fact, it's obviously a very long way from the present case. It is the reason why people usually go to Bankovic is it's the first case to look in detail at the question of jurisdiction. There had been other cases in Strasbourg which had touched on it, for example, Droj, Ilisec, Suring, and the United Kingdom to some degree as well, but not in any detailed and systemic manner. This was the first one to do it. You'll see jurisdiction picked up in the court's assessment at page 1138. There's a reference to at least one of those cases I mentioned, Droj, at paragraph 52. Reference then to the applicable rules of interpretation under the Vienna Convention. I don't need to go through that.
Sorry, wait a minute, which paragraph are you?
I'm so sorry. That's at page paragraph 53, page 1138.
Thank you.
My apologies, my lord.
There's me. Yes.
And then over page 1139, the meaning of the words within their jurisdiction. So what one takes from that is an introduction at paragraph 57 as to the ordinary meaning of the relevant term. Court is satisfied from the standpoint of public international law, jurisdictional competence of the state is primarily territorial. So again, stepping back for a moment, the learned friend puts considerable emphasis on the approach in public international law, quite right, but the approach in public international law emphasises territoriality. What then happens is that the court says, while international law does not exclude a state's exercise of jurisdiction extraterritorially, the suggested bases for such jurisdiction, including nationality, flag, diplomatic, consular relations, effect, protection, passive personality, universality, are as a general rule defined and limited by the sovereign territorial rights of the relevant state. And then there's a reference to the academic authors who have written about those issues. So that passage is dealing with suggested bases in public international law for extraterritorial jurisdiction. It's not a finding by the court that those are the bases. And in fact, what one sees then is certain of them are picked up, like, for example, diplomatic and consular relations, and I'll come back to that. But others are not in particular, so for example, nationality, flag, and so on and so forth. Accordingly, then at 58, states' competence to exercise own jurisdiction over own national is subordinate to other territorial competence. Then at 59, over the page, court is of the view, therefore, that Article 1 must be considered to reflect this ordinary and essentially territorial notion of jurisdiction, other bases of jurisdiction being exceptional and requiring special justification in the particular circumstances of each case. Now, just to flag one point, there's been some debate about the use of the term special justification. In my submission, that goes nowhere. It is quite clear that whatever else is said, extraterritorial jurisdiction is wholly exceptional in the conventional framework. It does exist, but it's highly limited, and special justification is in effect another way of saying that. But in fact, paragraph 59 is endorsed by the Grand Chamber in MN much later. So to suggest that it's moved away from that language is not correct, we say. There's reference then, I can skip over 60, it's got a very different situation, reference to the Travaux making a distinction between all persons, that is at 61, all persons residing within their territories to persons within their jurisdiction with a view to expanding the applications to others who might not reside in a legal sense, but nevertheless on the territory. So the Travaux support the territorial emphasis, albeit qualified at paragraph 63. The court, perhaps anticipating criticism, says we're not saying it's decisive, but it's certainly one of the factors that we can take into account under Article 32 of the Vienna Convention as supporting the analysis. There's then a reference to the Suring case. I indicated there'd been some earlier touching on this issue, and the phrase used in Suring at paragraph 64 was notably territorial. So again, no particular move from there. Extraterritoriality at paragraph 65, in keeping with the essentially territorial notion of jurisdiction, courts accepted only in exceptional cases. So this theme comes back again and again, exceptionality, that acts of the contracting states performed or producing effects outside their territories can constitute an exercise of jurisdiction within the meaning of Article 1. Then, skipping over the analysis of Loisidou and Droge over the page, if one goes to the bottom of page 1142, in sum, the case law of the court demonstrates that its recognition of extraterritorial jurisdiction is exceptional. It's done so only where the respondent state, through the effective control of the relevant territory and its inhabitants abroad as a consequence of military occupation or consent, invitation, or acquiescence, exercises some or other of the public powers to be exercised. There's then a reference to the McElhaney and Ireland case and litigation. I'll come back to litigation in MN, given what's been said about that. And then at 71, additionally, the court notes that other recognised instances of the extraterritorial jurisdiction include cases involving activities of its diplomatic or consular agents abroad and on board craft and vessels registered in or flying the flag of the state. In these specific situations, customary international law and treaty provisions have recognised the extraterritorial exercise of jurisdiction. Now, that passage is then added to slightly, both in Al-Skani and then examined quite carefully, for example, in MN, because MN was a case where there was an attempted argument about extraterritorial consular actions. It was a visa
When they say cases involving the activities of its diplomatic or consular agents abroad, what do those cases show the activities were,
So the
or types of
cases-
activities were?
yes, the case-
I just wondered, a matter of interest.
of course. So I can perhaps take this by reference to a textbook that's in the bundle. The case is
Just before you do, so I'm
Yes.
clear, 71 is additional to 69, is it?
correct.
So 69 is the cases show such and such, but we, the court, think 71 must be right as well.
Exactly. And in fact, what one then has in Al-Skani, and this answers the points of both my lordships, is in Al-Skani, I think it's paragraph 133, there is 132, there is a reference to some of the earlier case law of the Commission. So two cases called X in Germany, X in the UK, and
Right.
a third case called WM. Now, you don't have those in the bundle, but you do have a recent textbook which summarises what's in those cases. Perhaps if I can take you to those two short passages.
Okay.
So Al-Skani, which is going to be my next case,
Yes.
you will see that point I make on page 1276. And the reference is, if you look on 1276 at paragraph 134, first it's clear the acts of diplomatic and consular agents present may amount to an exercise of jurisdiction.
and they
Then it's
refer to some
important
cases.
qualification.
Yes.
When these agents exert authority and control over others.
Yes.
Now that takes you to the footnote,
Yes.
which references Bankovich, which you've seen, but then X, and WM.
Yes.
If the court could please take up volume 3. So we don't have those cases, but at the very end you have an extract from a recent textbook on human rights. And if the court could turn to page 2724,
Yes.
you will see those three cases dealt with at paragraph 6.45. And I just ask the court to read.
Just okay, this is written by you, is it?
Well, it is. I wasn't going to go to it, but it's only because it's the only place in the bundles where those three cases are described. 2724. I should say it wasn't me that put it in the bundle. This is the learner.
No. And you are happily a living author. Right. So where did we go to?
So it's at page 2724, paragraph 6.45.
I see this. Yes. Okay. And you want? Well, just read it.
Yes, if you could.
Yes. Yes.
So you can see effectively the cases are either dealing with classic consular assistance to nationals of the state in question in the diplomatic premises, or the very unusual case of WM, where effectively they were literally physically controlled.
Yes.
Highly unusual case, but that's the background. Of course, I should say to prove that I wouldn't have put this in myself. If one looks 1, 2, 3, 4, 5, 6, 7 lines up, there is actually a typo. It should say they exercise authority over. I did check the original text.
Sorry, where's that?
So 7 lines up from the bottom of page 2724, it should read, they exercise authority over such persons or property.
Oh, okay. Yes, I
So
see.
of
Yes, got it.
or due author.
Right. Thank you.
That's consular and diplomatic assistance. Perhaps that might be a convenient moment to break.
I think
I'll
so.
come back to
Me
that.
too.
Just get it.
Right, so we will start again at 2 o'clock.
Court rises able.